arbitration practice and courtroom mastery. He's a seasoned arbitrator. And most of the things that you will hear from all of our speakers today, they are going to be talking about real life cases, instances where they had to, disclose or something like this came up. So I would like to also welcome Professor Shodipo. Thank you so much for accepting our invitation.
Thank you very much.
Thank you, sir. Moving next, I would like to introduce Mr. Nathan Sil, who is a partner in the international law firm of Hogan Lovells. Is a partner in their London office. Mr. Nathan acts for multinational corporations in complex cross-border disputes with extensive experience across Africa, including Nigeria, Ghana, Kenya, and so many other countries. He's also a member of the LCIA African Users Council. Welcome, Mr. Nathan.
Good afternoon.
Good afternoon. Thank you for joining us. Moving on, I'll be introducing Jacqueline Wahiya. She is emerita. She prefers to be called emerita, and everybody now calls her emerita. She is the immediate past chair of the CIHAB Kenya branch. She's also currently the chairperson of the Institute of Certified Secretaries in Kenya, and she's also a pioneer in national policy reform. She brings to the discourse institutional perspective. I'd like you to welcome Emerita Jacqueline.
Thank you. Thank you so much.
And last but not the least, I would like to welcome Mr. John Aga. He's a corporate counsel. He is a deputy general counsel of Seplat Group. And he is also a fellow of the corporate governance professionals with deep expertise in energy, project finance, and transborder white-collar crime. I'd like to welcome Mr. John Aga to the discourse. Thank you, Doc, and my pleasure to be here. Thank you so much. So before I move on, a few ground rules. Before I move on and hand over to our moderator, if you are tracking CPD points, please, you do not have to do anything. You don't have to write your names or your enrollment number or your details in the chat box. To the extent that you have registered with your Supreme Court number, you will get your points allocated to you in due course. Please do not state out your details in the chat box. Then, please, we encourage an interactive session. Please post your questions in the Q&A box, in the chat box at any time, your comments. We hope that you will make this session also interesting with your questions and your comments. Please note that this session is being recorded for the Institute's purposes. Without much ado, I would like to invite the moderator to take the floor. I look forward to a robust and an insightful session. Thank you so much for joining us today and for your continued support of the Corporate and In-House Counsel Committee. Thank you.
Thank you so much, Dr. Esson. I want to thank and welcome our esteemed panelists. Thank you for joining us this afternoon. I assure you all, and thank you to our participants, I assure you all that we're going to have a very engaging and insightful session today. As Dr. Esson earlier stated, arbitrators have the duty to disclose, and they have a duty to be impartial and to be independent. Which leads us to the question, what are these duties and what is the Candour test? So we'll be opening our session by putting this question to the panel, and I'll start off with Professor Shodipo. Respectfully, sir, what is the Candour test? Yes, yes, sir. What is the Candour test, and what are the requirements for arbitrators under the Arbitration and Mediation Act and international best practices?
Yeah, good afternoon once again.
Good afternoon.
The Candour test, the word Candour does not actually occur in most arbitration laws, whether Nigeria or internationally or even institutions. However, candor means speaking openly, being honest and frank, means being impartial and being fair. And so in arbitration, it means that the arbitrators are meant to be impartial and they're meant to be independent from the inception when the arbitration commences all through, so that there will be no reasonable apprehension or bias by parties or any of the parties. And so all statutes, all institutional rules require and mandate arbitrators to have disclosure obligations. And you find out that the language usually is shall, a lot which is derives from the ancestral modern law. So arbitrators shall disclose any circumstance that may lead to justifiable doubts about their impartiality or their independence. This may include relationships with parties, with counsel, maybe previous arbitrations or previous cases. Maybe they've been witnesses. They played one role or the other. And the reason why this is important is for the efficacy of the arbitration system, because it's based on trust. And so you are expected to be impartial, and there must be no danger of bias. And because of this, the laws, including the Arbitration and Mediation Act in Nigeria, obliges arbitrators to not to be quiet, not to be silent. So if there are any circumstances which, okay, these are the arbitrators, the parties, these are the counsel, give an indication. It is for the parties to say we are confident or we are not happy with this, and maybe they ask that you recuse yourself, or rather than saying that, oh, I don't want to give an indication about this because if I do, maybe they may challenge me. It is safer that you are not quiet and you give an indication than you fail to give an indication and then eventually you're challenged. So in Nigeria, as it is with international arbitration, we have case law where, for instance, in Fezzel, where the courts, Dingba J, as it then was, held that a lady who was an arbitrator, who was a member of, who was an employee of the state government, Anambra state government, had indicated and disclosed that she was at the beginning of the arbitration. And so when the arbitration award was challenged at the end of the arbitration, the court held that no, she had fulfilled that duty, which is disclosure. So the word impartiality, the word independence occurs several times in our Arbitration and Mediation Act, and that's because of the importance. It refers to absence of bias or predisposition towards a party, and independence is characterized by the absence of external control. So these are things which help the arbitration system. I think maybe I'll stop there because of time. Thank you.
Thank you so much, sir. Thank you for giving us a better understanding of what our duties are. And this duty arises right from the beginning of arbitral proceedings and throughout the length of the arbitral proceedings. And that leads me to my second question for you, sir. Where do arbitrators most commonly misjudge this duty? That's the purpose for this discussion. You've told us what we know what the duties are. Arbitrators have a duty to disclose. But where do arbitrators most commonly misjudge this duty?
Well, the question is, should I or should I not? And I'd say you should, if any reasonable person looking at the circumstance will feel that there is a predisposition of impartiality, that you are no longer that you are now partial, and so you need to disclose. in Nigeria, there have been a number of recent cases where people have been challenged as a result of this. In another case which Justice Dimba presided over, the chairman of the panel was challenged because he had not indicated that he was involved with an arbitration which affected the parties who are involved in at ICSID, which is the International Center for the Settlement of Investment Dispute. But the interesting thing was that the judge held that the panel had a right under the Arbitration and Conciliation Act, which has been repealed now and replaced by the AMA, but the same provisions that they have the right to determine if they are challenged. So I would say that anything that could make the parties wonder whether you will be partial, it is safer to disclose. And the test, like I said, is a reasonable man's test, the test of a third party person who is looking at the circumstances and would determine, suggest that circumstances which you did not disclose suggest that maybe you are partial or impartial. I can't hear you.
Okay, can you hear me now, sir? Thank you
Yes,
so
certainly.
much for establishing that for us. And in consideration of the objective test, my next question goes to Madam Jacqueline Wahenya. Madam Jacqueline,
I'm here.
thank you so much for joining us.
Thank you. Thank you for having me.
You're most welcome.
Yes, yes.
So what role should arbitral institutions and appointing authorities play in safeguarding independence, impartiality, and neutrality? Kindly share your thoughts.
Yeah, thank you. Thank you so much, Oluwakemi, and everybody for having me on this call. Like you heard, I've had the privilege of being the chair. I'm chair emerita of the Kenya branch. And in that role, I think I had the privilege of appointing almost 800 neutrals to about 800 disputes. And while we agree that the role to disclose the Candour test really lies primarily with the arbitrator, the institution also has an important role to play. Now, speaking from the perspective of CIAB, CIAB London has the code of ethics for professionals. It's easy to find, it's online. It's a CIAB code of professional and ethical conduct for members. And part 1 of that code speaks to, first of all, the members who are appointing to, first of all, be disinterested. That is what Rule 1 of Part 1 says, to be disinterested in the appointments that they are making, so that we can be able to take the step of checking first that the neutral who has been appointed, the arbitrator who has been appointed, is suitably qualified, and they have the capacity and the experience to be able to carry out that particular the dispute, the reference from the beginning to the end. And because the responsibility lies with the arbitrator, then the first thing, the most important thing, when we, at least in the Kenya branch, we have a two-step approach. We nominate a neutral, and we tell them that we intend to appoint you to this matter. Can you tell us if you have anything, or there is anything in your past or relationship with the parties that would bring into question your impartiality and independence? So we have the first bar to ensure that the party or the arbitrator is discloses any relationship. If there is any disclosed relationship, then we default to the IBA guidelines on this disclosure of conflict of interest. And of course, I think we are fairly familiar with the traffic traffic test, the traffic light system. so that they are the non-waivable red items, which nobody should be entitled to take up any arbitration or reference. There's also the waivable red list. So this enables the parties to say, well, we have heard about this, and we think that maybe it would be okay. We want this arbitrator to be the one to handle our dispute. There's the orange list. And one of the interesting things about the orange list is that it has been updated in the 2024 edition of the IBA guidelines. So it's good to take a look at that and also be very clear that we are not offending or you don't fall within this. Of course, the green list, they say that you don't need to disclose this. And I think of interest to us is the academic sociability test. But then there are instances where because this is a guideline where we have found, even the courts have made determination on this. So there's one example I just want to give, and this was an ICC matter. This is a Douala Port Authority case where the chairman of the tribunal in that case knew the counsel. And then when unfortunately the counsel passed away, he wrote a very flowery obituary talking about, oh, you know, he opened up to me, and many times I would counsel him when I'm making important decisions. So because he wrote an obituary and there was something that could be pointed or pinpointed, the French Court of Appeal, first of all, set aside the final arbitration in that case. So we find that even in the international plane, even institutions, we're not able to find out all the detail of the relationship between the parties. And I wish I could say that even in Kenya, we have not had that trouble or that problem or challenge. But then obituaries, deaths, weddings, social engagements, academic relationships, they may come into play when we are asking ourselves this particular question. So from an
Thank you
institutional
so
point
much,
of view,
Ms. Jacqueline.
yeah.
Thank
I
you
think
so
that
much
would
for
be
giving us
interesting.
the perspective from the arbitral institutions perspective. I would like to call on Mr. John Aga for the next question. Mr. John, can you hear me? Mr. John, can you hear me? I think he might have dropped offline, so I think I'll just direct my next question to Nathan. Nathan is joining us all the way from London. Thank you for joining us.
It's a pleasure.
Yes, and my question to you is why has disclosure and candor become such a heightened issue in arbitration today compared to a decade ago? What has changed?
I mean, I think there are a few themes or trends around why this has become an issue. I think the first is social media, and there's a lot more use of that, and so conversations that would happen in a social setting and wouldn't be recorded are now available for people to who even don't know the arbitrator to search. So you can look at their LinkedIn profile, look at what they've commented on, look at who they're connected with, look at who they're congratulating or celebrating. So I think that's one that there's more information out there and available to parties to look at. I think there's an increasing number of arbitration conferences. And so issues about talking on panels or appearing and endorsing people's books, and again, more touch points around those more data points that you can use to show that the nature of the relationship, and and particularly as the arbitration community is very social. And then I think there's also the trend of double hatting. So we've got people who act both as arbitrators and as legal counsel. And that's an area where
Arbitral rules, like, can you hear me? Hello, Nathan, can you hear me?
sorry, I can hear you now. Sorry, you dropped out there for a moment.
Hello, Nathan. Hello, Nathan, can you hear me?
Yes, I can hear you.
Okay, fantastic. Yeah, there was a bit of a lag there. In the UK and under major international arbitral rules like the ICC and the LCIA, how is an arbitrator's, sorry, arbitrators must disclose any circumstances that cast doubt on their independence. How effective is this requirement in practice? So we want us to share your experience because you've worked a lot in Africa and in a lot of ICC and LCIA arbitrations. How effective is this requirement in practice? Could you share from your experience?
Yeah, so again, the ICC and the LCIA ask arbitrators to make disclosure, and the institution will then help to provide guidance and assess that disclosure by reference to the IBA guidelines. I think it's fair to say that where you're a party appointed arbitrator, it's best to over disclose because the institutions will pass on that disclosure and ask the parties to comment on it. And I have seen disclosures like talking about the double hatting where an arbitrator says, I also act as counsel, and I want to be able to continue to take new appointments as counsel from the law firms, on either side of this arbitration. Now, I think that's a bridge too far. And we've sort of objected where there's sort of been this attempt to get an advance waiver. So that's one of the areas where, again, arbitrators will say, well, look, I'm being transparent about what I want to do, so the parties can agree that. But when it comes to institutions appointing, for example, the chair, I think that's where they'll apply quite a lot of scrutiny. And if you've got a disclosure, then if you're either being appointed as a sole or a chair, they will share the disclosure with the parties. But often the institutions will take a view and say, well, look, it's our reputation as an institution, and we're going to apply more strict criteria if you're sitting as a chair or a sole arbitrator. And then the excellent thing with both the ICC and the LCIA is that, if disclosure is incomplete and there's a challenge, that both the LCIA publishes on its website all of the arbitrated decisions in a summarized and anonymized format, so you can see what issues there have been. And the LCIA, a good example of the fact that their process for getting disclosure right at the outset is that very few of the challenges are successful. And the ICC also in its bulletin publishes, I think the last issue is where this was dealt with was 2016, so they may be coming up again, I think, to publishing some more, but they've also published anonymized decisions. So those are a useful resource if you're trying to get your head around, well, what is going to be good grounds for a challenge and what is not. A lot of the ones that are not are, well, there's been less about failures to disclose, but more, there's bias from a procedural decision that's gone against me. And in most of those cases, those are quickly dismissed.
Thank you so much, Nathan. Thank you for sharing that. So I'm going to direct my next question back to Professor Shodiko.
Yes, I'm here.
Yes, sir. In light of the decision in Global Gas Refinery Limited and the Shell Petroleum Development Company of Nigeria, where reference was made to the IBA guidelines on conflict of interest as soft law and therefore merely persuasive, is it safer to disclose everything, just like Nathan has also adhered to, or does over-disclosure carry its own risks?
Like Nathan said, it is best to disclose. It's safer to disclose, and maybe you may lose the appointment if you have to, than you don't disclose and then you challenge, because it can be emotional, even for where you are being challenged, and it's as if you have hidden something, So in that case, it was an ICC case. The chairman was challenged because he was alleged that he did not disclose that he had acted for one of the parties in a previous case. Actually, he gave an expert opinion against one of the parties, not for the parties, in a previous case, and that was not disclosed. When he was challenged, like I had said earlier on, the panel held that they had jurisdiction and they did not. He did not recuse himself. The case went on to the ICC court. The ICC court, yes, referring to IBA rules, did say that he in the circumstances was not one of the ones that he needed to recuse himself. But when the award was given, the award was challenged in Nigeria, and the High Court of Lagos held that he should have recused himself. I understand that they've appealed, that the High Court did not refer to the IBA rules. But they've appealed to the Court of Appeal, and the Court of Appeal had sent the case back, saying that the court did not look at another part of, the enforcement part, when the case of enforcement and challenge were consolidated. And of course, they have also then appealed to the Supreme Court. But the point I think I need to make about that is that the IBA rules are soft law, and our courts, if they are referred to the courts may decide that, oh yes, we want to follow the IBA rules, because under the IBA rules, the circumstances which they presented did not amount to one which, I think Jacqueline also said, is not a red waivable. It was an orange circumstance. So IBA rules have not necessarily been endorsed or by the courts in Nigeria, but they are certainly soft law and they can guide. Now, in an arbitration I was involved in, because it involved the Lagos Court of Arbitration, their rules and did incorporate the IBA rules. Because the rules incorporate the IBA rules, that means those rules, IBA rules, are applicable in such proceedings. So I think that's what we need to look at. If the rules do not incorporate, then it becomes soft law. And if it is soft law, it certainly is persuasive. And the general rule of thumb for me would be that, look, check the circumstance. Does it fall on one of the ones which IBA suggests you should not be involved in? Then recuse yourself. But if it is not, but it is important, first of all, to disclose, because the first rule is disclosure. But finally, I must say that the fact that you did not disclose does not mean that the award would not be enforced. And I think maybe when we ask other questions, particularly Nathan may be able to highlight the English decision of Halliburton against Shaw, where the Supreme Court in England did say, yeah, there may not have been disclosure, but this is not sufficient to maybe to set aside. Thank you.
Yes. Thank you so much, sir. Do you have any personal experiences that you want to share with our audience?
Well, in
about 1 minute, sir.
Yeah, a couple. I've had to recuse myself in a matter which when we started the case, I had said there were no issues, but then they changed counsel. The claimant changed counsel. I wanted a senior advocate, and when this firm of senior advocate came, they said, "Oh, Prof, you are a witness. No, you are a claimant in a case where we cross-examined you." And I said, yeah, I was. You have all the facts. I disclosed it to the parties. The respondent said they were not worried about that, but the claimant felt that I should recuse myself. So I took on jurisdiction and I said, no, I do not need to recuse myself in this situation because it falls under the rules in IB where I don't have to recuse myself, which is enmity between the parties. And I said, there's no enmity between us. So there's a lot of cordiality between us. But eventually I did resign because I felt that let me let the parties go ahead so that I won't be the reason why they are challenging this. And the other one was I was counsel, and they were able to stop the challenge because you need to also, if you're going to challenge, to file your challenge within a few days. In many rules, it is 15 days. In some rules, maybe 30 days. So in that case, it had to do with the MM2 airport. And we were able to strike out the challenge because they did not file within time. Thank you.
Thank you so much, sir. Thank you for sharing your personal experiences. We now want to look at how in-house counsel, how they approach the issue of disclosure. And I'd like to call on Mr. John Aga for the next question. Mr. John Aga. Mr. John Aga, can you hear me? Hello, Mr. John Aga. Okay. Miss Jacqueline, while we're waiting for Mr. John to rejoin us.
Yes.
I would like you to share, in your experience, how do tribunals and institutions determine whether a financial interest is too remote or gives rise to justifiable doubts?
Oh, okay. From an institutional perspective, and I think I had one of these when I was appointing. One of the questions that we ask is the financial, the levels of fiduciary relationships between the individuals. And the key things is to check whether the arbitrator has some decision-making authority over one of the parties. So that is one of the areas. If they are on the board or if they've had a governance role in the financial institution, that is too close. It really is too close for them to be able to be considered that they can be independent and impartial in a situation like that. When it comes to shareholding, this one is a tricky one because the test of materiality is the one that we have to put in place. And the question obviously starts with what are the number of shares? But you know, when you look at the governance structure of any institution, some shares have stronger, let's say, voting power. Some of them have a stronger financial implication because the value is higher. And it could also, you also want to look at, is there a difference between the nominal value or the nominal capital and also the market capitalization? So those are all considerations that must be taken into account. Of course, if you go to the IBA guidelines, and I want to stress that even when we're looking at the IBA guidelines, it's not a safe harbor. We use it as a guideline, a framework, something we can look to, and it's useful for determining the language. But a factual consideration is so critical because the financial relationships also tend to be very interesting. Okay, if for instance, an individual has taken a financial what do you call it, a loan or a mortgage, they're in a very different role than somebody who is on the board of directors of an institution or a shareholder, or if they have some capital, or if for one of the institutions have, you know, the holding companies because of the structure and the relationship between those institutions, or if that individual is a beneficial or a beneficial owner. So there are a lot of dynamics that come into play. But when we ask for the institution, even if you receive that information, the first rule of thumb I would say for us is that we don't keep the information as if we're in a silo. If it's information, it needs to go out to the parties, but it needs to go out in a manner that also protects the privacy of our members as well. So it's a real balancing act. I would not say that this is the silver bullet. It's a question of looking at the facts, looking at the personal relationships, looking at the dynamics, looking at the value, the monetary value, yes, but there's also a fiduciary value as well. And I think I can also just refer to, there's a case called Avax versus Technimont about the changing and the dynamics of companies because some are acquired, they have this new, what I call third-party funding When you have those kind of structures, you want to be sure. So in the tool of the institution, then you must have somewhere where you'll be able to say, can you respond to this table? And I know the ICC does that. And you give the details of if you are related to the to the parties, and if there's any relationship, to what extent, so that even as the institution is making the decision, they're not just being what do you call it, rubber stamping and just saying you just get on with it. Yes.
Thank
That
you
is
so
what I-
much for
Yeah.
sharing with us that institutions they do a conflict check, and they do a due diligence check as well into the arbitrators before they are appointed. So thank you so much for sharing that. My next question goes to Nathan. So Nathan, in African related arbitrations seated either in London, Paris, or Dubai, how do disclosure failures play out differently from those seated locally?
Well, again, it comes back to the the fair-minded test, and so it's you know really putting yourself in the position of a fair-minded third party. Would this give rise to a reasonable apprehension of bias? And that the venue for resolving that issue will, if it's under LCIA or ICC or other institutional rules, be in the first instance the institution. Then potentially the courts of the seat, and then obviously on enforcement. I think the things to look out for is making sure that what is the fair or reasonable-minded observer. That's all impacted, and I think we need to be conscious of this, by our own experiences and by our own environment and culture. And so that's why looking at the previous challenge decisions, help look at the principles and applying them to the facts and circumstances of the case. I think it would be useful to give some practical examples here. So I was acting as counsel in an arbitration, and one of the arbitrators found out from his fund manager that he had some shares in one of the parties. These companies were both listed on the London Stock Exchange. This particular arbitrator had someone else managing his pension fund, and found out during the arbitration. So he disclosed that to us. There were a small amount of shares in this big listed company, and both parties agreed that this, in the context of this arbitrator's position, I mean, he didn't even know about it. It wasn't something that was going to influence how this arbitrator made a decision. He was a well-established arbitrator, and someone who was a former judge in the House of Lords. So again, look, at those circumstances, the parties were happy to say, well, look, that's obviously not going to affect your independence. But as Jacqueline was saying earlier, actually, if you're a shareholder, in a private company, and even if it's a relatively small shareholding, if that is significant, and if the amount in this, that the value of the arbitration is likely to make a material difference to the performance of that company, then the assessment will be different. Thinking about again some of these word examples, I was approached to be appointed as an arbitrator in a dispute where one of the parties was there's a question mark over the financial position of one of the parties, and my firm was represented a bank who had made a loan to that party. Now, usually you would not think, well, acting for someone who's making a loan to a business wouldn't be a grounds, but I felt I had to disclose it, given there was this allegation about its financial solvency and position, that potentially down the track, my firm could be acting for one of the would-be creditors, and in that case, the institution decided to appoint someone else. So you can sort of see it's
Nathan,
a very unique scenario, and it's not one that's covered by the IBA guidelines, but it's what someone reasonably thinking, well, look, it could be a relevant factor.
Okay, Nathan, please could you hold that thought, because I'm going to ask you another question concerning ICSID arbitrations that I know that you have experience in. I'm just going to go back to Mr. John Aga, because he hasn't had the opportunity to speak to us. Thank you so much for joining us, Mr. Aga.
Yeah, thank you, Nika. Thanks. At last I'm here.
You're very welcome. In your experience as in-house counsel, what are the yardsticks for appointing prospective arbitrators, and how proactive must in-house counsel be in investigating arbitrators beyond what is disclosed?
Okay, thank you. Well, it would be easy for me to jump and say that the yardstick for appointing a prospective arbitrator is independence and impartiality, but I wouldn't go that way because from my experience, since you have asked of my experience as an in-house counsel, let me start by saying these are the things we do once a dispute has arisen and it is a matter that you have taken a determination that it should be resolved by arbitration. The very first thing you do is to take a review of that particular contract document. And that exercise is important because over time, you find out that if you assume that there is actually an arbitration clause between you and the other party, and you proceed, you may end up undertaking an exercise in futility. So experience has taught us, you review the contract document, and you now find out where is the arbitration clause. And looking at that arbitration clause, is it the type that actually can be enforced? Is it enforceable, or is it a clause, what we call a pathological clause in arbitration? And speaking of this, we have had life situations, where we assumed we have a clause in our arbitration that did not mention, in our contract, that did not mention the place of the arbitration, did not actually even the choice of law was not mentioned there. And at the end of the day, we had to find a way to resolve it. So it is always good when you make a determination that the matter will be resolved, you look at the contract, is there an enforceable arbitration clause? If there is, then the next thing you now look at, is it institutional? Or in other words, what are the numbers of the arbitration? So arbitrators, then you then begin to then say, what then are the qualifications for the selection criteria we use as an in-house counsel? You also find these instances where a dispute has arisen and you take a look at the dispute, the nature of the dispute, find out that it is one that can be resolved through arbitration. But you find out that at the point of drafting, all these things happen under intense condition. At the point of drafting, dispute resolution mechanism was just not exhaustively drafted. So there is no clause at all. Then in such a situation, you engage the other party. And when you both agree that the best way to go is to resolve through arbitration, you may do a submission agreement. So these are the preliminaries we take into account. Then before you then narrow it down to what then will inform my choice of arbitrator, the very first thing is that arbitrator that will be impartial. Let us also remember that the fact that I appoint an arbitrator to sit in a panel doesn't mean that that arbitrator must give an award in my favor. No. The duty of the arbitrator is to look at the fact and the evidence impartially and come to a conclusion and give an award that is fair and just. So independence and impartiality of the arbitrator is very important. And in fact, it is the bedrock of the whole process. In terms of
Thank you so much, sir.
In-house.
Thank you so much for sharing
Okay.
that. I'm so excited that you're able to join us and give us that perspective. Thank you so much. I'm going to come back to you with
Thank
a
you,
very
Kemi.
interesting question, but I'm going to direct the next question to Professor Shodipo. Yes, sir. Sir, is proof of actual bias required, or the appearance of possible bias sufficient when we're looking at the objective tests that you talked about
Well,
earlier?
yeah. So I think maybe I need to backtrack first that, like I said, it is wise and safe that if you are in doubt, just disclose. Now, if then your challenge, whether that situation will cause bias, is not proof of bias. It's whether there could be bias. If a third party looks at the situation, that is what the courts have looked at. And I think there was a case where the Supreme Court actually the Supreme Court actually made some pronouncement which could be instructive on that, that it is not real, whether there was, and then the onus would be on the person who is making the allegation to show that there is a likelihood of bias.
Thank you so much, sir. We have a poll that has just come up, and I'm just going to give participants a bit of time before I move on to the next questions to fill the poll. Kindly fill the poll, and I'll share the analysis.
Yeah, so
You've
can
got
I
30
quickly
more
just,
seconds.
So, can we please continue with Mr. John? The poll is ongoing.
Okay. Thank you so much. Thank you, sir, for sharing with that. I'm back to Mr. John Aga. I said I had a very interesting question for you. And I think your professional experience working in the oil and gas sector will come to light as you answer this question. Mr. John Aga, are you still with us? Can you hear me, Mr. John Aga? Okay, while we wait for him to join us back again, I'm going to direct my next question to Nathan. Nathan, I earlier stated that I had a question for you concerning ICSID arbitrations. In light of the fact that there's a lot of, there's heightened awareness and discussions regarding transparency, what are your thoughts on the issue of disclosure when it comes to investor-state arbitrations?
I mean, I think it's very important in the context of investor-state arbitrations because you have the public interest, and the size of the dispute is often much larger than most commercial disputes. But I think the underlying principles are the same. You want an independent and impartial tribunal to decide the dispute. So I think it's and a lot of the I think the one advantage of arbitrators in the ICSID space is that you have the ICSID panel. So they've been put forward by the and vetted by the institution, in advance, and also many of the awards are published. So they create, again, that data point, and you can look to see, what connections and what decisions particular arbitrators have made, and that's that's important. But again, the arbitrators, if you are asked for an appointment, you still have to think, well, look, there's so much publicly known, but it's still important to be able to ensure your disclosure points to that, because you may have parties who aren't as familiar with the body of case law. But I think that's what I'd say about exit arbitration, that because of there is more published information, it is sometimes easier to get data on potential arbitrator candidates.
Thank you so much for sharing that. Mr. John Aga has joined us back again. Thank you for joining us back again, sir. So my question to you is, what does an award being set aside for non-disclosure mean for a company's balance sheet and reputation?
Thank you so much. Let me bifurcate the question. You may have an award in your favor, and it happened that it is set aside. A whole lot of things, it means quite a lot for us in-house. Let's say I have an award of $50 million, like I have now, in my favor, and the other party is seeking to set it aside. First, if it succeeds, it means that my contingent liability has increased. That is the liability I'm exposed to. And these are the things potential investors, we have to look at. What is these people's contingent liability portfolio? It discourages them. Nobody wants to put in the money into an investment, put an investment into where you are not sure of the type of liability they're exposed to. Then the other part of it is, it depends also on the reason. If it was because of this failure of an arbitrator to make necessary disclosure, and that is what an in-house counsel we should have discovered if we had done our due diligence, then it becomes embarrassing to the business and also to the management. So there is reputational loss if the award is given in favor, is set aside. It also increases our contingent liability. Then on the flip side, if it is award that is given against me that is set aside, I think it is all rejoicing. It will reduce my contingent liability. It also will show that we have actually done what we need to do. So the one that we worry most is where we have award in our favor and the other party is seeking to set it aside. That is the one that poses serious danger to us as an in-house counsel because of its impact on the potential liability, on the contingent liability, which may affect investors' confidence and their willingness to continue to invest on us in our business. Thank you.
Thank you so much, sir, for sharing that perspective from the business side of things, that it does really impact a business when an award has been set aside due to issues of non-disclosure. Thank you so much for sharing that. I'll now call on Madam Jacqueline.
Go ahead.
Madam Jacqueline, can you hear me? Yes.
Yes, I can, loud and clear.
Okay, fantastic. In international practice, is it common for institutions to withhold disclosures made by arbitrators, or does the burden rest strictly on the arbitrator to disclose to the parties?
That's a tricky one. But most institutions, whatever information you disclose to them will in one way or another get to the parties. I, for myself, I belong to the school of thought that says, look, disclose everything. I don't think there's anything that is too much disclosure. And on the part of the institution, you just want to maintain the trust in the whole arbitral process. So that we are getting the right people into the right references. So there are instances when, okay, well, we feel that some of the information that you're providing may be unnecessary, but the way we train our arbitrators is, thank you for disclosing that. We will still appoint you after you've given us your feedback. But we would encourage you to disclose this and any other matters that may come, because disclosure is not a one-off event. It is a continuing responsibility on the arbitrator. And of course, for CIAB, we have ad hoc arbitration. So actually, once the institution has made the appointment, then the chairman of the institute is functus officio. But then with the, and I think the other institutional approaches, ICC, ICSID, LCIA, all of them will have a process through which you get the information, you send it out, and then the parties do with that information what they will. And sometimes, because institutional arbitration is a continuous process, if new information comes up, then you may find that what the institution will do, they will interface with the arbitrator directly without necessarily getting into it with the parties. And then if the arbitrator is inclined to make that disclosure, then they can then take that particular step. Or otherwise, you invite them to, and I think this is the language we always have when we're engaging with the institution, the arbitrator should really consider taking this step, informing the parties of this new development, of this information that has come to our attention. And then the arbitrator then takes the necessary step. So it's a balancing act, sometimes a tight balancing act, but everybody has their responsibility. Not only the arbitrator, but the institution itself should keep a tight lid on things, if only to make sure that the trust in arbitration continues to endure. So I do believe everyone has a role to play. For the council, those who are engaging with the institution, it is also important for you to understand or look at the rules. How many days? I think ICSID is 21 days within which you should make a challenge on the basis of information which has been disclosed to you. Because after that, then you're considered to have waived that that particular issue and agreed that you will be bound by it. ICC, I think, has 30 days. And one of the interesting things, maybe I can just share quickly, an experience I had with the international institutional approach. Of course, you disclose, I'm Kenyan, and one of the parties was a country, a sub-Saharan country. And one of the challenges that came very quickly under the rules was that you cannot be impartial and independent because you come from Africa. So it's also important for institutions to appreciate that some of the parties and their council, when they're engaging with the process, may not be as alive. So it became very interesting to watch a ping pong between the parties when the Sub-Saharan African party then very quickly challenged the other party on the other side, saying that you're being racist, you're being, what do you call it? You're sexist. So the institution very quickly jumped in and said, no, I think this one, let it go and let's continue with the arbitration. So there are very many interesting experiences that we have out there, but please engage with the rules of the institution in the right and proper way. The institutions are they're usually, today, they are very, very responsive to especially such questions as disclosure and challenges as the case may be. Thank you.
Thank you so much, Madam Jacqueline. So your recommendation is that we should disclose, and the arbitrators
disclose,
yes, okay,
because the institution will protect you if it becomes challenging. Yes.
Okay, thank you so much. I'll be.
I can hear you.
Can you hear me, sir?
Now we
Yeah,
can.
I can hear you.
So I believe all our participants have had the opportunity to fill in and join us with the poll. And we'll just be sharing the analysis of the poll at this time. So I'm just going to bring up the poll question. Okay, so I can see in the comment section that the poll is still ongoing. and I'm going to give the audience the opportunity to continue with the poll. So we'll do that shortly before the question and answer session that will be starting in about 10 minutes. So just to round off our session here today, which has been so insightful and engaging, I'm just going to give each of our panelists the opportunity to share their final thoughts. And I'll be starting off with Nathan. Could you in 1 minute share what practical steps or what practical tips you would give to arbitrators concerning the issue of disclosures?
My practical tip would be, look at the IBA guidelines, understand the challenge decisions from the leading institutions, and then so that you can, in your mind, identify things that are clearly grounds for refusing an appointment, clearly matters that either don't need to be disclosed because they're on the green list, or are ones that you disclose but won't be a basis for you to recuse yourself. And then you'll be left with some that are in the middle, that are close to the line. You're not sure, do I disclose it or not? And my advice is, if you are asking yourself that question, I'm not sure, do I or don't I, err on the side of disclosing. Because if it is something that you say no reasonable party will worry about it, well, then you should assume that the institutions and the parties will agree. As I say, if you're not sure, my advice is disclose.
Thank you so much, Nathan. Professor Bankole, your final thoughts on the issue of
I always assume that there will be one of the parties that may not be happy with the award and may want to challenge. So I don't want to give them an excuse. As a result, I'll disclose, knowing that you have a power based on what Nathan said, looking at the IBA rules and so on. You have the power as a panel to decide whether that is sufficient for you to recuse yourself or not. And then you may decide to just recuse yourself. But it is important that you disclose, because there are lots of authorities in Nigeria and internationally where having disclosed, the courts have held that the tribunal has a power to determine and go ahead with the case. So disclosure, I think, is important. Thank you.
Thank you, sir. Madam Jacqueline, your final thoughts, please.
Yes, so my final thoughts are, when it comes to disclosure, this is fodder for any party who is dissatisfied at the end of the day to raise a challenge. So, and there's no way you're ever going to be able to preempt or to know in advance who is going to raise such a challenge. So if you're the arbitrator, then you need to be as open. I think the word we used was candor. Your candor must be very, very open to disclosing everything that could come up as in any of the arguments that may be made in the future. For institutions, because that is my perspective, it's important to lay out a timeline when the waiver would then come into play. It's important to have a metric for you're just measuring the materiality. So materiality requirements are also pretty key. And then also be ready to deter speculative and strategic challenges, because with each year that passes, we have seen a very huge spike in challenges in relation to conflict of interest. So we have to maintain the disclosure regulations, and then just make sure that your metric is looking at something that is relevant, is contextual, is capable of objective assessment. And then also, in addition to just looking at the challenges, also provide a procedure for those challenges to be made in the first place, so that we can be able to address them in a manner that is also transparent, full of integrity, and we can be able to say that this is and accountability metrics. So everybody has a role to play, mostly the arbitrator. The institutions also have their place. Counsel on both sides, we also ask you, please, counsel, only make those objections which are relevant, contextual, and capable of objective assessment, because we've also come across very interesting, we might call them frivolous objections, but everybody's entitled to make them. But let's look at what really builds the process as opposed to just
Thank you,
tearing
Madam
down.
Jacqueline. Thank you
Yes,
so
thank you.
much.
Yes, yeah.
Thank you. Yes. I'll be inviting Mr. John Aga to please share his final thoughts. Mr. John Aga, are you still with us? Okay. I'm sure he will join us soon. He's been having some issues with connectivity. So we'll be going into our question and answers session. There are lots of questions in the chats. Unfortunately, we might not be able to cover all the questions, but we have a lot of interesting questions that have been put up by our audience. And I'm going to start off with the first question. The first question is from Sylvia Garuba. It says, what is the extent of disclosure necessary? Are casual meetings in social settings or even on social media enough interest to warrant a disclosure? So I'd like to, Professor Shodipo, if you could kindly take that question.
If you are in constant touch with some people's social media, it may be good to indicate. You just don't want to give some people an excuse, because what people want is just an excuse to challenge. The casualness of it, once it's disclosed, you may decide that you are continuing, even if it is objected to. And invariably, most likely, the courts may hold that, yeah, you had a right to continue. But if you don't disclose, then the question may be, why didn't you disclose? Because there's some of it that you may not even know that you are on LinkedIn with somebody. So this is just raising more challenges for all of us, all stakeholders in the industry.
Thank you so much, sir. Thank you for answering that question for us. The next question is from Mrs. Fumi Roberts. And it goes, the golden rule is, if in doubt, it's actually a comment. So I'm just going to read it out. So Ms. Fumi Roberts has commented that the golden rule is, if in doubt about whether to disclose or not, err on the side of disclosure. Thank you so much for sharing that, man. The next question is from Wasiu Amal. As beautifully crafted an arbitration clause in an agreement is, the cost of filing for the arbitration proceedings is costlier than litigation. What can be done to make it more appealing to participants and encouraging? I'll be inviting any member of the panel to answer this question. So it's open to any member of the panel to answer this question.
I think
Professor
most
yeah.
institutions have reviewed their costs. I know SIA Nigeria, UK Nigeria has reviewed, and I know some other institutions have reviewed costs because they want to encourage arbitration. So, but you have to pay for arbitration. That's just the truth. So you either choose to pay even with the ones that have reduced, or you choose to go to court. And hopefully the arbitration ADR system will continue to deliver.
Thank you so much, sir. Thank you. So we just have a few more questions, and I'm going to direct the next question to Ms. Jacqueline.
Okay.
Yes. So the next question is anonymous. It says, are institutions liable for when they appoint an arbitrator and disclosures are not made?
Okay, I think the quick answer is no. There's no liability in the sense of can they be sued? But then what tends to happen is that if you have many appointments where the challenges are successful, then the trust in the institution ends up suffering. So the reputational impact cannot be waved away. So there is an impact, but liability in the sense of can you be sued and successfully sued in court? I doubt that. I think that is a quick answer. But then there's a reputational risk that definitely attaches from one too many arbitrators who are appointed without really going through the necessary safeguards. I think that would be my best answer.
Thank you so much.
Yeah, and if I
Yes,
may
sir.
join in, there are some statutes that, including the AMA in Nigeria, that give immunity to arbitrators, mediators, and also institutions, unless you can prove that maybe there was malafide activity, which may be difficult to prove.
Thank you so much, sir. So the next question goes to Nathan. It's from Iretioluwa Banjo. And I'm just going to read it out. When an award is set aside due to non-disclosure of an arbitrator, should the arbitrator bear or refund the cost of the arbitration, considering that the parties have expended so much money on the arbitration?
As Professor Shodipo just said, in most arbitration statutes, including the Arbitration Act in England and Wales, the arbitrators have immunity from suit. Now, if you can show that the failure to disclose was fraudulent, then there may be the possibility, but absent clear evidence of serious fraud, there is not the ability to pursue the arbitrator for wasted fees of an award that's set aside for non-disclosure.
Thank you so much, Nathan. Yes. And my next question goes to Mr. John Aga. Hopefully he'll be able to share his parting comments and answer the next question. Mr. John Aga, are you with us?
No, he's no longer with us, Kemi. Please proceed.
Oh, okay.
Asking others.
Okay, I see. So the next question, which I think will be my final question, I'm just going to invite any member of the panel to answer. It's from Adekunle Jegede. It says, please, what are the duties of parties and counsel in regard to non-disclosure and candor as it relates to confidentiality and evidence guidelines in the arbitration process? Jacqueline, would you like to answer that?
The thing is, I think the challenge is that the question that has been asked looks at two very broad areas, gathering of evidence, and IBA also has another guideline on gathering evidence in the arbitral process, and disclosure, which is also covered by the IBA guidelines on the conflict of interest. When it comes to conflict of interest, I think we don't really follow strict rules of evidence to demonstrate whether a tribunal or tribunal member is impaired in their independence and impartiality. Like I said, we look at whether it is something that would be relevant. The question is the arbitrator then, if you can demonstrate, and the demonstration really just needs to show that a reasonable man would consider that being with this impairment, having that financial interest, having that personal relationship or contact with one of the parties or the counsel for the parties would they be really expected to be able to go through the entire reference without being influenced to favor the party they have a relationship with? So it would be useful to, because this is a fact-finding question, and when it comes to the question of whether an arbitrator is independent or not, sometimes if we receive, now I'm speaking from the institutional perspective, credible information, which we can double check and confirm. Are you a member of this firm? Has this firm given an opinion? Has this firm acted for? Were you part of the team in that firm? Then it tends to give us the inclination to want to advise the arbitrator, please, as a matter of candor and for the benefit of your independence and impartiality, either disclose, or if you feel that this is not going, is going to fall within the red non-waivable items, just recuse yourself and step aside, let somebody else who can be able to be independent and impartial to take over the reference and carry it to fulfillment. Because at the end of the day, we want to maintain the trust in arbitration itself. So yes, thank you. Thank you so much. I can see my sister, Sola, the chair of Nigeria branch. It's great to see you. And Happy New Year to you. And thank you all for the opportunity to engage with you this afternoon.
Thank you so much. We have a few more minutes for the question and answer session, so we can take one more question.
Okay, can I
For
say
the
something
panel.
about the last question?
Yes, kindly go
Can you
ahead,
hear me?
sir.
Okay, so there was, I think part of the question, it was a loaded question. Part of it was on confidentiality. I mean, certainly, it's one of the foundational things in arbitration, and if anybody breaches that as counsel or as parties, they may be proceeded against under maybe professional rules or under a suit in common law for breach of confidentiality. But of course, if the proceedings get to an award stage and there's a challenge, then it limits what can be confidential. Unless, of course, there's some cases where some particular things in terms of evidence is also supposed to be redacted and should not be made public. So it's not so straightforward. Thank you very much.
Thank you for sharing your final thoughts on that. Thank you, sir, for answering the later part of that question. So I'm just going to take one more question before we round up. So Miss Julius Ejikoye is asking, if a party has challenged an arbitrator in a previous arbitration, should that fact be disclosed in a subsequent arbitration involving that party? So Nathan, I'm going to direct that question to you.
I think it depends on the circumstances of that challenge. As Professor Shadipo mentioned earlier, if this is a case where there is enmity between the arbitrator and the counsel, if there have been allegations of deliberate non-disclosure or particular ties, that as the professor said, that can give rise to quite some emotions, particularly if there's an element of dishonesty being alleged against the arbitrator. So in those circumstances, it ought to be disclosed. However, if it was more a technical question and the challenge was resolved by agreement, for example, then it may not be something that warrants disclosure. But I think it will be one to look at very carefully in the circumstances, and certainly if I was in the shoes of the arbitrator, that's something that I would be seeking to disclose, because I would have to be disclosing the fact that I've that this is the second arbitration that I've been an arbitrator in where this counsel has appeared. I think in the context of making sure that disclosure is full, you would also want to say, and in that arbitration I was unsuccessfully or successfully challenged. Again, it just puts the matter beyond doubt. If either of the parties are concerned about it, they can raise it and deal with it at that point. What you don't want as an arbitrator is to not disclose, get to an award, it comes out, and and the parties in the institution are saying, well, why did you disclose? There's now an application to set aside the award.
Thank you so much, Nathan, and thank you to all our panelists. Thank you for all the insight that you've shared, and thank you for your time. This brings us to the end of our session, and I'll just be calling on the chairman of CIAB Nigerian branch, Mrs. Olushola Adegbomire, to share her her closing remarks.
Thank you very much. Thank you. This has been a very, very interesting webinar. One that I had also been looking forward to since it was announced. It's the very first webinar of CIAB Nigerian branch for the year 2026. We had quite a few interesting ones in 2025. This is the first for 2026, and it's been hosted by our corporate and in-house council committee. They've done a lot of work in 2025, and we're looking forward to such great webinars again this year. I want to thank all the speakers. I mean, there are people that I've been looking forward to listening to. Jacqueline, my very dear friend, the past chair of the Kenya branch. I call Professor Shodipo my supervisor when we get there. And Nathan and Mr. Aga, thank you so much. I've been looking forward to listening to all of you, and I'm so glad I attended the webinar from the very beginning. I mean, these are things that we sort of assume we know a lot about, but when we hear it like this, we learn so much again. I mean, imagine an obituary becoming the basis for challenging an arbitration. There are many things we really need to look out for. And so much has come up in this webinar that the only thing I know is there's no small thing to disclose. I mean, right now, the things we are seeing are challenging even the green list of the IBA guidelines. So, I mean, it's better just disclose everything. Red, of course, we have to disclose. Orange, well, disclose. But now there are things coming up, even in the green list, that it's looking like we have to disclose. Maybe there'll be another version or another edition of those IBA guidelines. But obviously, where we are now in 2026, in this time, is disclose, disclose, disclose. Don't consider anything too small. Things that people have felt, oh, it's not really important, have turned out to be very important. I mean, someone didn't disclose about being an in-law, and everybody knew that the person who was challenging also knew. It wasn't information that was hidden, but the courts didn't see it that way. So in everything now, let's just disclose. That's what I hear from all the speakers, from Prof, from Nathan, from Jacqueline, from Instagram. All I can hear now is disclose, disclose, disclose. Thank you very much. Thank you to the committee, the in-house council committee, the whole team. Thank you to the moderator. You did a great job as well. And I'm really glad that I attended. We're looking forward to the next webinar. And please, I know they keep saying it, please, if you attend another webinar, please, there's no need for you to put your name and your MBA number in the chat. Please, there's no need. We will get all the information and we will send it to the appropriate. And also, a form is usually even displayed if there's a need for it. And then everybody just downloads the form and fills it. Please, going forward, we appeal because each time you put your name, it pops up, it pops up, it pops up, and it's a distraction to many people. Thank you very much. Thank you for engaging, for all the questions. Thank you for engaging. If there were no questions, it would seem as if nobody was really listening. But we had so many questions, we didn't have time to take it. So thank you so much for engaging so well with this panel. And we look forward to
the next one. Chinelo, please, if you can post, if there's time, our next program, it'll be nice. But once again, thank you very much. Dr. Esma, I see you. Thank you.
Thank you very much, ma'am. Our next webinar is in February, the first week in February. It will be, the information about the webinar will be circulated, and we hope you will join us again. My madam has thanked everybody. I will just chip in. Thank you all for coming, the speakers. Each and every one of you were fantastic.
Fantastic.
And all the participants, thank you for joining us. Without you, we would have had a successful webinar. So we appreciate your time, and we look forward to you joining us next month and in subsequent webinars. Thank you very much. The results of the poll, I hope you have seen it. It was shared, and that's it. So it's always a 90 minutes session. It's a hard stop, and so we stop here. Thank you very much. And for the questions that have been posted, we'll try to respond to them. We have your details. Those that we could not, address here, we'll try to respond via email. Again, we appreciate all your time, the speakers, the moderator, and the executive committee members present, and all the senior lawyers and all the participants and members of the committee that are present. Thank you very much. Have a great day.
Thank you.